Good evening and welcome to Legal Tech Live episode 77. We are here with Camila Lopez and Gustavo Lozano. They are the founders of, is it Courtam or Courtam?
Courtam.
Courtam, okay. Courtam, you can find them at courtam.com. This is small claims legal technology. This is the first time that we've covered small claims issues on the show. And joining me co-hosting tonight is the Kerp. Adam Kerpelman from Get Juris is on the show. I asked him to come out and play. He got approval, and he is here to ask the questions, the hard-hitting questions that we ask on this show. So, Camila, thanks for joining. Interesting, was looking a little bit at what you're doing. Looks like kind of guided small claims assistance at kind of fixed rates. Is that a good summation of what you guys are doing? Just kind of very basic for the listeners.
Right. Like a very broad level. It's we guide people throughout the small claims court process at a fixed, affordable price. And we connect them to legal service providers where they need it. So attorneys, process servers, and ideally someone to help them prepare for their trial.
Okay. And generally speaking, at least in California, you don't need legal representation for small claims, correct?
Exactly. So so the whole thing is attorneys aren't allowed at the hearings, but you can have an attorney provide you legal advice before and after the hearing. So that's the key.
Gotcha.
You can get attorney advice to coach you through the hearing, but that would probably be very expensive. And you can have attorneys actually, once you get to if the case gets appealed to the Superior Court, an attorney will still come in, and the other one is collections as well.
Gotcha. So, and Adam, you feel free to jump in. I don't think that you'll be shy here. Right? That's usually I don't look for shy co-hosts.
You picked me for a reason.
Yes.
Yeah.
So you jump in when you want, but tell us a little bit as to how you had a background, Camila, in consumer protection and consumer rights law. How did you and Gustavo decide to start?
So it was actually his idea, but I would say I inspired him. He's the tech, I'm the legal.
Right.
Basically, I went to law school. Aaron Brockovich was my inspiration. I don't know if that's too overused. No. I mean, I love it. Like even though she was a paralegal, I want to be, I've always wanted to be Aaron Brockovich. So that's my history. I've worked as a paralegal in tobacco, plaintiff side cases in Florida. I've worked at the New York AGs, at the Bureau of Consumer Frauds and Protection, and also at a products liability firm. So I would always tell Gustavo about these things. And so one day he told me to take him to small claims court when we were living in New York. And so I took him to a small claims court. He knew there was something there. We didn't know exactly what. So we started investigating, and we've been investigating for some time now. Then fast forward, we moved to California, passed the bar, and we start really digging deep. And we've been going to small claims court and checking it out. You want to continue from there?
No, it's okay. That's the story. And then we found a lot of problems. Like every time you go, I think you feel frustrated because everybody gets frustrated. So you want to help. You can right there, but it's just you see so many people doing so many mistakes on really silly things, on things that are like you see, oh, that's easy, but people don't know. People don't understand. Even me, when I go, I'm like, what is that? Or what did the guy was saying? And she needs to tell me in like normal words what is the judge saying to the plaintiff or the defendant that is there. I don't know if they're basically understanding what the judge is saying, but
Well, they're not. That's what we found. They simple things as service of process. You go to small claims court and people are like, so the clerk will ask them, all right, where's your proof of service? No one, like maybe 50% of the people know what that is. The other 50 are like, everyone's looking around, everyone's stressed out, the clerk's in a bad mood, the sheriff's in a bad mood, no cell phones. It's a nightmare. So, I mean, obviously it also depends on which court you go to. Some tend to be a little bit nicer and a little bit better about using plain English to explain simple things such as notifying the person you sued about the lawsuit. But it's something I was taking for granted that Gustavo quickly realized no one knows what's going on here.
So this is nope. Does somebody have us on in a different tab? I'm getting some feedback. Is that your fancy setup, Adam?
Shouldn't be. I don't have speakers.
Okay. I
Only
think
headphones.
I think it's gone away. So this is an issue, right? This is a standard issue with just about all legal services that lawyers are now. There's a movement to speak in plain English. You see that movement taking place, but small claims is supposed to be the thing that individuals can do on their own, and it's not that easy, is what we find. So, and right, service of process would be one of those items that this should be easy, but notifying the person that you're suing them.
Right. That we found is one of the biggest hurdles for people. Not even just like understanding what it means, but a lot of people still think that they can serve themselves. It's surprising how many times a person will come in and they've served their own lawsuit, as well as failing to bring in the proof of service. So proof that they actually have done it. And a lot of people think that, oh, the court will just do it. Yeah, there is a system in place in California where the court can serve by mail, but even the court clerks have told me that it's ineffective almost 99% of the time. Some say 50%, some go all the way to 99%. So it's not working. And people just don't know what's going on. So that's where we come in.
Go ahead, Adam. I see it brewing.
What? Oh, no, I was just thinking about a time that I was in traffic court, even as a youngster, but like growing up with my dad as a lawyer. I was in traffic court once and the officer didn't show up. And so I already knew at 17 years old or whatever I was at the time, oh, I'm pleading not guilty because he can't, the officer's not there to represent their side of the case. And there were maybe 3 or 4 other people the same day that just got up and said not guilty. And the whole time I was going, oh no, guys, they got up and said guilty. And I kept going, no, you're trying to be good people. I get it. But all you had to say was not guilty and they would have dismissed you just like they did to me. It's like,
but imagine people
tricks,
who
right?
have no access to the legal system in their whole life. Like people who, we don't come from parents who are lawyers. Like when I remember my first day as a paralegal, I had no idea what was going on. The word motion made absolutely no sense to me. Even now, Gustavo catches me speaking to people and he's like, stop saying those words. So I've had to like rethink, just going back to the basics. I'm not a lawyer, pretend like back when I wasn't a lawyer and just speak normally, speak like how normal people speak. That's how you get people to understand what's going on. And the court is not doing it either. You can find all the information online on the court's various websites, and it's not clear. It's very hard. Even for me, I have to sit down, write it all out, and go to the rules of civil procedure and figure it out. And it's not simple.
Right. Yeah, it's really interesting with the access to justice or the justice gap issue that we have going on in this country. We're figuring out just how messed up the procedures and the processes of doing this type of work that should be easy, but it takes those of us with a law degree to actually analyze and then try and now communicate that in plain English.
Yeah.
And it all happens in a really scary building.
Scary building where nobody is happy.
It's intimidating to go there.
Yeah, one of the first times we went, we all stood up for the oath just because we didn't want to be the only people sitting down, and we knew we were testifying. I was telling Gustavo, sit down, we're not testifying here. He's just like, just get up, and the people being like, get up, like give the oath, and we're like, okay, we'll just do it. So now I just always stand up like a normal person, and that's it, because some of them, like the sheriff will take your phone away. It feels like you're back in a Catholic middle school where you weren't even allowed to do, like, I don't know, anything. So
Wow.
it's scary.
The funny thing is that so we have interviewed people that have gone to small claims court and people that haven't. And it's funny that people that already went to small claims court, not everybody, but there's a set that they say, oh, it was easy, I will go again. So there's a fear to go, but once they start going, they we ask a simple question: will you go again to small claims court if you have another issue? And most of people say yes.
Right.
Interesting. So that's the facing your fear type of thing.
Exactly. So it's like, oh, once you go there, oh yeah, like once I figure it out, once I know the process, once I know what to say, I lose the fear. I can go again. If I have another problem, I will go. I don't have any problem. But when you start asking people that haven't gone it, it's like, I need a lawyer.
Yeah,
I don't know what to do. I don't have time. It's too difficult. So once they go in, then their mentality changes.
Yeah, interesting. And I think what you probably found out, based on what I see on your website, is that they don't necessarily need a lawyer either. They need some assistance in filling out paperwork and making sure that they do the processes right, and filing the paperwork. And so you can guide them without actually they think they need a lawyer, but what they really need is a guide.
Yes.
In
some
cases, okay.
Are complex enough that maybe a lawyer, but you don't need a lawyer for. So one of the things that I have in my mind is today, there's like a mentality that you need a lawyer for your whole case. And a lot of the time for a lawyer is doing process stuff, filing, process service, things that you can do yourself. And it doesn't make sense to pay a high fee for that. Mm-hmm. So if you can unbundle the whole thing and only pay for the parts that you need to pay. So I only need a lawyer for this advice or for this advice, then the whole process, the cost of the whole process is way less than just hiring an attorney for the whole case and help you to go through the whole small claims court case. When you just need, okay, I just need some help at the beginning and then some guide to go through the process, and that's it.
Okay.
And potentially, again, if you win your case and the person doesn't pay, so at the collection stage, that can get pretty complicated as well.
Sure. So tell us a little bit then about what you do, what Courtam does. So give us if I'm the person who's looking to come into small claims court right now, today, and I don't understand what's going on, I go over to Courtam. What's my process as a user?
So first, we're an invite only right now. So if a person, we give them an invite, they go in, they answer a series of questions that we've essentially, we'll filter certain cases out so that we're getting like the very streamlined cases, not in terms of content, but like government claims tend to be a little bit more complicated, attorney fee disputes, those as well. So we filter those and we get just breach of contracts, like the typical small claims court cases, breach of contract, security deposits, auto collision, and then they'll go in, fill out their information, and so then it's giving you a checklist. All right, first you fill out your information to file the case, but before that, we suggest a lot of information that would be relevant, like when you're going to go put the date. We give them examples of statutes of limitations. That's one of the biggest ones. We do a lot of suggesting versus telling them this is what to do, and then give them links to more information where they can find themselves. And if they cannot find the information within the information we've given them. We say at this point in time, we tell them, you need to speak to an attorney, blah, 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 blah. But ideally, that's not how it's going to look like in a month from now or in 2 weeks from now. So we work really quickly at iterating, but we're at the stage of building that platform, which right now there is a platform there, but we're just working on making it better. And then you go on, checklist, you filed the case, then you have to give them information on how to serve the defendant. We give them the options of hiring a process server, which we connect them with one, or they can serve themselves for free, as long as it's not themselves, but anyone that they know over the age of 18 that can serve the defendant. From there, it's evidence management and receipt management, because in small claims court, if you win your case, you can get your costs paid for by the defendant, reasonable costs. Evidence management, case receipt management.
And then we help them, depending on which tier they paid, we help them organize that evidence and prepare them for court. So a lot, like when you go to court, people go really disorganized. So if you can help them organize the evidence, it's like supposed to be super simple, but if you organize the evidence by date and then you walk the judge, hey, this is how you like present your case, then it gives them a higher probability of winning their case or winning more, like a bigger claim.
Right. The evidence management platform, like we love it just because it's like dates, describe what it is. Is it a picture? Is it a contract? Why is it important? And then upload the file. And then that creates a little document and you have everything organized. Because what we've seen is that people will show up with a bunch of papers. They don't even know what they're looking at. They're nervous. And then the judge will actually send them back into the audience to organize their papers and like look at what they're looking for. And then ideally they would also have like their proof of service there, because that's one of the biggest things that they forget to file and then forget to bring with them. And then that's it, go to trial.
Excellent. I want to thank Chris Canjero, Mark Palmer, and Joe Regalia for tuning in tonight. If you guys have questions for Courtam, the founders of Courtam, please post them in the Facebook group. It looks like we also have somebody else attending. Looks like Johan Drolshagen is here in the Zoom room. So if you have questions, please ask them. So Adam, please, you're up.
I had an idea and then I was distracted by the Zoom room. That just sounds like a great place to hang out.
It does sound like a good place to hang out.
No, I have. So you mentioned a beloved word in the sort of startup space, and so certainly the legal tech space. You said, iterating toward your toward your final product. And more broadly, I think that's a really interesting thing to talk about in the legal space, because like it sort of embodies the move fast and break stuff mentality of a lot of, I guess I would say the tech space broadly, or at least the mythos around the tech space. When you're dealing with legal tech, I mean, this is the thing I'm very familiar with working at Juris, but it applies with what you're working on as well. We're dealing with legal tech. You can't move at the same breakneck speed in terms of rolling stuff out, right? So I've talked to a lot of investors and go, yeah, we're in a beta and it means we're working with this number of people and this number of attorneys, and we can only move so fast because cases only move so fast. But also, if we mess it up, like I'm hurting another human being, like right. In the context of rights. Yeah. So I'm curious what your experience is on the sort of small claims, with what you guys are working with in terms of just how you think about that stuff and what you've bumped into. And
I think that's the struggle between both of us.
Absolutely.
Yeah. You guys have the struggle right there between the founders on that, huh?
But actually, come on, give me some credit, okay? We at first we're like, all right, we're gonna wait all this time to launch, to build this, and then I started watching a bunch of startup school, Y Combinator startup school videos, and I joined the tech side, and I was like, wait, that makes no sense. Like, we need people coming in as soon as possible, seeing what works, because you don't know what works until you talk to users. So now I'm like that mentality. Talk to users, build product. Talk to users, build product. And it's like that. It's tough. I mean, it's not easy. Sometimes I get all scared. I'll call a professor. Do we need this to be live, to be selling this? I mean, like, we're incorporated, yay. But it can be tricky. It's been tough to get me to move over to that side.
But yeah,
but that's what you need.
At the same time, there's been moments where we have like stopped and it's being delayed. Things have been delayed because we need to abide by the legal laws and legal, like, remember when we were doing the legal
like licensing
and stuff. So we need to stop and say, okay, perfect. First, we need to put everything in place before we just keep iterating. But I think when you're iterating, we haven't had any big challenges. We're small still, so we are able to help people one-on-one a lot. Mm-hmm. And that help us improve the product and tell them, hey, now you can use this. And it's easier because it's still one-on-one. We don't have like 100 to 100 cases going in.
Like all at once.
Yeah, so we have been able to manage it. So, but and Cami has been able to manage with each case that comes in and give that personal experience for now as we grow.
Right. It's focusing on the individual so that later we can scale. Like right now, it's still very, very individualized, so we can really listen to what the users want and what they need and what are their biggest pain points. So.
Excellent. We have a question here from Mark Palmer, who's with To Civility in Illinois. And he says, in Illinois and likely elsewhere, courts have struggled with whether or not corporations, LLCs, etc., may be represented by non-attorneys, even in small claims cases. How do you handle this as part of your intake or lawsuit kit packages? And I will let Mark know you guys are only in California at this point, right?
Yes.
Right.
We talk about the legal assistance, the legal license.
No, so I think this question is different. So he's asking if how businesses can send their representatives to represent them that are attorneys. I mean, we want to focus also not just on individuals, but businesses as well. Sure. And you still have to train the employees on how to go to small claims court and represent the business. Because here in California, they do allow employees other than the owners. They don't allow attorneys. So no matter, even if you're a business or whatever entity you are, it's not an attorney who's going in at the first instance to the hearing or handling that part. But they do send their employees. One of the biggest ones is Opportune. But we've seen other ones as well, like wedding caterers, and it's getting the employees to understand how it works. So like at the end of the day, there's still an individual who, if they don't go to a small claims court often, don't know how it works. Okay.
All right. And so, and Mark says, right. So if you have a small biz and the president wants to represent herself, okay.
So we would help that person, the owner or their employees.
That would be your user in that situation.
Exactly. Which we're really trying to figure out how we can help businesses more, offer a few different products for them, but that's still in the works.
There's a special paperwork you need to file so to be able to appear as a representative of a business.
Say that again one more time, Gustavo. There's what?
So there's a special paper, like a special form that you need to file to represent the business as an employee. So we help you through that too, like how to file and that authorization to appear form.
Okay. All right. That's good to
know. Which is something barely anyone files before the hearing. Yeah. You show up on the day of court and everyone just hands it. No one knows what they're signing, what they're doing, and just hands it in, and it makes the court system extremely inefficient. So we're actually also helping the courts.
which
getting
they
people
need.
organized.
Yes, they need. Go ahead, Adam.
Win-win.
It's interesting how, you know, there's it's easy for a bunch of lawyers listening to this, I think, to go, well, I could see how everyone having a lawyer would clean up some of these misunderstandings. But on the other side, you have the deliberate limitation caused by not having a lawyer, right? Like not requiring a lawyer unless you're going to go so far as civil Gideon and guarantee everyone a lawyer ends up being an object that throws a case into being not fair. And the point is to, have a fair outcome of the case, ideally, right? So they say no lawyers,
right?
And that means you're just going to have this incoming stream that kind of jams up in the way that you're talking about, in a way that, I don't think something like guaranteeing that there are attorneys in the system necessarily fix it. I mean, I like the idea because everyone should be represented, but as a systems thinker, I'm immediately like, oh, but that's what's jamming it up, is that the incoming stream of information is literally a person going, I got this stack of papers. Even if you're a corporation, you have a legal department, you're not even allowed to show up as a lawyer. So you have to coach an employee. It never even occurred to me that you'd have to coach an employee to like go do the thing. And it's interesting.
Yeah,
But you would actually also be surprised, because I've seen lawyers in small claims court going for the appeals, like when the small claims court the case gets appealed, it's still in the same room, and even they don't turn in the form. So
small claims court, like what I see is lawyers don't know about small claims court because they don't care about that. It's $10,000 or less. Why go there? Like I prefer to go to the $50,000, $500,000 case. So now you have also a gap in knowledge in the legal field where nobody knows about the small claims court process.
Even the lawyers.
Yeah, I don't know. I haven't had to file anything in small claims. I'd have to start from scratch like any other consumer.
Absolutely.
Yeah, I don't know what it's.
If my startup wasn't so close to the space, I wouldn't have a personal reason to know. I mean,
right.
Nothing's come up. I mean, I know where to go though. You
know where to go, and you can probably figure it out, but it will take, just like any other legal issue where we have to come up to competency on it. I'd have to gain competency on the issue because I honestly don't know. But I know how to learn that. But for a lot of consumers, that's not as easy. So we do have some questions. Chris Canjero and Mark Palmer have some comments here, but I wanted to get to, you guys are very early stage. You're in beta still, you said?
Invite only, so yes.
Invite only, okay, invite only. So how's the adoption on the invite only side right now? Are you actually helping people through small claims issues? You hear that they have a small claims issue and you invite them to try it out?
Yes, and a lot of them have also been collections cases as well. So sometimes we'll have to go back to the drawing board, and we have to figure out what the best product is for the users. Maybe it's only a piece of the small claims court process that they need the most, or maybe we have to figure out collections first. So, I mean, I think that's the hardest piece, is figuring out.
That goes first. Yeah,
yeah,
we have both. We have some cases on collections, and as it's interesting because as we do interviews, some of them get interested in coming to the invite process. So that's mostly how we're getting a bunch of users. And also she's super active in social and Instagram, and so there's also an intake there.
That's good.
Yeah.
So what we focus on is converting a lot of our initial user studies that before we were like, okay, let's start building like a big product. We did a lot of user studies, and we focused on converting those people who had disputes but hadn't been to small claims court. And we've gotten, I mean, if you're not on social media or Instagram, Facebook, we actually do get people through those channels as well.
Yeah.
Okay.
Which at first I had no idea how people were hearing about us, but hashtags.
Yeah.
I guess.
That works.
Yeah.
And Instagram's a great place to sell for something like this, especially when it's a limited amount, limited scope service, essentially.
And we don't want to grow as fast because we need to really flesh out the product really well before we start growing fast.
I've been trying real hard to figure out how to use TikTok to promote Curious,
I'm
but
still waiting.
I love TikTok.
I got nothing so far.
I downloaded that like 3 days ago.
But I think what you were saying relates to something that we run into as well, which is just the nature of it. It's back to the nature of iteration in legal. But the reality is you have to go at a pace that's very like, you bring someone in, there's essentially a client and you're helping them through this process. And then you don't get to try it the next time again until the next one comes down the chute. And there's a lot of data out there and you can kind of make a lot of guesses to start, but until you just start working with customers. And so we have, very frequently the numbers are, well, how many people used this before you made this shift? And I'm like, 10, but it took a significant amount of time and it's a very involved process. And so then I end up having to explain to, whoever I'm talking to, like, well, yeah, but we learned a lot because it's not like somebody come into your app and they either click the button or they don't, and then they're out, right?
It's not that graph that the investors want in legal
right,
tech.
the hockey stick.
Yeah, they don't. That doesn't really happen in legal tech because it's a great point that you bring up. The adoption is not the same here. You can't get that hockey stick adoption with, oh, well, now we have 300,000 users after 6 months. Yet. Right, because there's other rules that apply. It brings me to a question that I tagged you in on Twitter the other day, Cami, which is really, and I know that you're aware of it because you responded to that. It was essentially a graph. I'm trying to think how to explain this for listeners only as well. It was a graph showing basically in 1980 there were something like 600,000 small claims suits filed in California, and I don't know if it was 2010 or 2017 or something like that, and it's down to like 192,000.
Yeah, it's 100.
While the limit has gone up to 10,000.
The limit has gone up to 10,000. Yeah. Did you see that? Did you see that graph as well, Adam?
Yeah.
So the limit has gone up, but the number of claims have gone down. Do you guys know? Do you have any data for us to explain as to why that might be happening? Is it that people just don't understand? Is the process has become more convoluted?
I think it's difficult to pinpoint one issue. If you start also checking other research, you see that the trend is not only in small claims court; it's across the board. Even for federal and state cases, it has gone down throughout the year. And you find a lot of hypotheses about like why is this happening, but from our research on a small claims court, to answer your question, like we think, because we don't know, but we think there's basically like people solve their issue before going to court. That's one. So because people are afraid to go to court, they try to solve the issue more before going to like small claims. So they settle the cases more. That's right. One that we think. The other thing is the one that we also talk a lot about is the public fear of going to court, of the legal system. Like we don't know how the legal system works, and I need an attorney. So they just don't move forward with the case. And that also, goes in hand with another study that I read that was like 57% of cases like don't act, like disputes don't actually, like people don't even find an attorney or they just drop it. So 57% of cases are dropped and people don't find an attorney or move ahead with the case. And that also goes in hand with what we found, that because we were interviewing both people that went and people that didn't go. I think, like, based on the data I got, around 10 to 20% of people move forward with their case. Okay. So they drop their case because of different things. Like, they think they need to check with an attorney when they don't, but they just want to take it. So they don't have the time to do it, or they need to read a lot, and it's just a pain. So nope, I don't want to do that. So they just drop it, and that also impacts the number of cases that like are filed and that stats that you are seeing. And the last thing, and the third thing is, I think that was actually, I read the tweeters, was about arbitration. I don't know what the impact is on that, but of course people are going through different ADR solutions, arbitration solutions to like solve their disputes. But it's weird because I was seeing the data of the number of cases. Like, if that's the case, then if you see the arbitration number of cases per quarter or per year, it should be really high, and they're not as high as I hoped. Because if I see a trend going down on small claims court and arbitration is the cost, then I will see a lot of cases in arbitration going up. And I don't see that big correlation, like, oh, this is going down, this is going up. So I think it's different things at the same time actually pushing the trend down.
Yeah, I saw I've seen the comments on the forced arbitration clauses. I'm not sure if I buy that that's what's preventing it.
Plus, a lot of those, there's a lot of arbitration clauses I've gone through, and a lot of them have an exception for small claims court. Okay. That you can still bring your dispute in small claims court. So we're a little hesitant about the arbitration one. But just from people we've spoken to, having to get an attorney for their case, even they don't know the rule that attorneys aren't allowed in small claims court, is a huge fear that they have. And some have even told us that attorneys have quoted them $1,000 to handle their small claims court lawsuit. So it's just
because it's not worth their time. So they're gonna. I would do the same thing. I'd quote somebody a price to keep them from coming back. Because I don't want to spend the time.
So my question is, where do you think that, like, what, there's especially in legal tech, we're always talking about ways that technology can solve it, and process related things and efficiency related things. But like, why are clients coming in preloaded with that feeling? Like, I mean, it's a misunderstanding of the system, but I have my own theories, but I just like to ask other people before I spout off. Where do you think it comes from? The idea that everybody has that they need a lawyer, and or just that layer of fear associated with the whole process. I
think normal people look at movies, shows. A lot of these people will tell me, "Oh, it's like Suits. Like, that's what I'm going to expect at my hearing." I'm just like thinking back of what episode of Suits was terrifying. Yeah, okay. It is a little terrifying sometimes. If you're prepared, is what we're trying to get back to them. Like, small claims court was made to be easy, quick, affordable, efficient, and all those things. And it hasn't gotten through to the people. And sometimes it isn't as efficient and quick and affordable as they want it to be. So, we really want to create a small claims. It's the people's court, okay? That's what it was created for. And we want it to go back to, it's very, idealistic. I'm like that. I want to be Erin Brockovich. What can I say? But there is something beautiful that you have a dispute, you were screwed by someone, and you yourself can go fight that dispute at the people's court. It's not opportune's court. It's the consumer's court. It's individuals, small businesses, medium-sized businesses, and it's bringing back that, the do-it-yourself, like, you can do it, fight for your own justice. And people love it. Like, people don't like pro tem judges, but that's a whole different
that's a whole different story. So basically what I'm hearing from you, Cami, is this is Adam's fault, having come from the entertainment industry.
That's why I'm so aware of the extent to which it's our fault. You gave exactly the answer that I do, which is there's no way to say this without dating myself on some level because I have to make pop culture references. But yeah, I mean, it comes down to like, we need more night court and less Law and Order.
Yeah.
But the reality is, like, you know, the People's Court, unless you're talking about the, you know, daytime television version of it where it gets kind of hostile, like, is generally boring compared to criminal court, right? So the pop culture representation of lawyering and you know, it's like, you better lawyer up, 2 exclamation points, you know? And so that ends up being that. Exactly.
With that whole Law and Order music is even intimidating, right? And that's what they
have a running joke in the industry about the person who made up that sound being the highest paid Law and Order,
sure.
Like the royalties for that
sound. But that is where the fear, we've certainly that has proliferated the fear, I believe, or helped it to proliferate. Chris Canjero says he's interested how you support your clients navigating through the filing process. He thinks the court process and pretrial paperwork requirements would be the most intimidating part for the inexperienced. You seem to think that that's part of it. That part is somewhat intimidating. Can you dive a little deeper? Is the responsibility still the clients, or do you take some of that on as part of the service? And I think you did describe this, he may have missed part of that. You do help them with the collecting of the evidence beforehand.
Yeah, I mean, simply it's easy information, translating the questions into simple, like, you look at the form, it seems kind of simple, but then having someone fill it out and see what parts, they don't understand what it's saying. Or they're asking, is this necessary? Is putting the defendant's phone number necessary? So things like that. I don't know if people are aware of Clerky, but that's a really good example. They just make it really, really easy by just asking simple questions instead of convoluted questions. And then giving them, like, what we do is, like, on the right side of the page, they can click a hyperlink and it gives them more detailed information of what something means if we don't think we're being as clear as we can. So just simple. I mean, I pass it by Gustavo. That's my test. Like,
that's your
if
test.
If you understand, then
and users.
That's my first one.
But yeah, we
most
help.
of the times the first version's not that good.
We help through the filing and through the serving and through the collection.
This is a question we didn't ask at first, and allow me to, we maybe should have. Are you only servicing plaintiff side? Or if somebody gets sued and they're like, well, shoot, I don't know what I'm supposed to do in small claims court. Will you be offering that?
To be honest, the platform right now, it's focused only on plaintiff, but we do defendants to help them out on a case by case.
Yeah, we have one right now.
Okay.
So if somebody's like needs defendant, we can for sure help them, because it's not totally different, but it has some different process that we need to like change the system a little bit for that.
We also have like collections and appeals. Like our web app right now is focused on people who it's the initial case filing and you're initially going to the court and all the way through your hearing, but it doesn't cover appeals yet, and collections and defendants, counterclaims. We're working on that, and hopefully we're quick enough, but we just help them manually for that and individually. So
excellent.
So yeah, not a lot of cases, but
not for those, for like the random ones we've been getting that.
Yeah, but it helps us
still
learn.
help them.
Yeah, it helps us learn a lot. So that's part of the learning process.
Yeah.
Excellent. Kerp, what do you got going in the mind there?
I was thinking about, it's just the thing we run into in Juris as well, but and then I end up talking to lawyers about it a lot. But you know, I think from our perspective as the trained professionals, it's easy to, or I would say, a type of trained professionals, right? Like when we were talking about the process, I kept wanting to go, normal people don't like paperwork like we do. Like when we think about how we design the system.
Yeah.
But on the other side of that, there's also a reality that they want to know what's going on, and designing an educational experience that allows them to go deeper to understand what they're doing, I think is a really important part of this that you guys have talked about doing and taking seriously, and that we kind of deal with as well. But it sort of comes from this place of remembering that people do want to know what's going on. They want to understand the context of their situation. And my belief is if you want to take them as deep as like, here's the actual law, like you can read it if you want, it's going to be dense. Like
it's not going to be entertaining.
Why not have that hyper thread exist if they want to pull it? But on the top level, just sort of the faith that they even want to know is where that starts from. And I think a lot of people just sort of dismiss it, going, they just want to be told what to do, and then we don't have to think anymore after that. And we've not really found that to be true. I mean, it sounds like the same.
That's interesting. Have you guys found that, Cami and Gustavo?
Yeah, and even before we started Courtam, and one of the reasons that I felt like, okay, we should launch Courtam and do this was because I was helping two pro se plaintiffs go through federal cases against big corporations. And I think I was so amazed by how much I could teach them and like easily explain how things worked, and just even like citations. And they really amazed me. I really think most people don't need a lawyer to do all this. A lot of people have, there's people are super smart, and if you give them the right tools, the right tools phrased in a non-lawyer way, and non-legalese way, then they can do it themselves.
Yeah, that's interesting.
Attorneys where it gets hard, and while there's the case is a small claims, it's a monetary small amount, but the law sometimes can get complicated, and that's where we need a lawyer.
The question I had on the back of that was for Gustavo. How long did it take you until you could just translate the phrase pro se, like in your head, and remember what it meant?
Yeah, wow.
I mean, that's a perfect example of what we're talking about here, though. Lawyers just say it, and we all know what it means.
Yeah.
But normal people look at you and go,
plaintiff, I didn't know what it was. Like,
right.
Which one is which?
Yeah, I know. It's like that with most people. And he's educated. Ivy League MBA. He's smart. Yeah, okay.
It's like that with every profession. If I use the term concatenate, normal people don't know what I'm talking about either, but programmers do.
Right. That's it. Well, that's the thing about law and programming that I think are an interesting parallel, is that they are just learning a new language, essentially, both of them. And then there's the rules to those that are laid out in those languages. But if you're a standard American who, MBA or not, it needs to, they've got to breach a contract between their neighbor and them for cutting down some trees. And we wrote down, we're going to share the cost here. And then you go and try and figure out your way through something like this. It's a nightmare. And I think you guys are both right, Adam and Cami. I think people do want to do these things themselves. I don't think the explosion of the DIY everything was just a result of saving money. I think a lot of people have an interest in learning how to do these things themselves. And I don't think that small claims should be any different than that. But again, I don't have data to support that. These are my opinions. But I do believe that there's a need to accomplish these things, or that people have a need to understand it. Because like you've said already, once I've done it, I'm ready to go back to small claims court. You said that earlier. Okay, because the fear of it is gone.
And the DIY culture is ingrained in American culture.
You bet. You bet. Should be able to do this myself.
It's like when you fix the car, why not when you go to court?
Absolutely. So, Adam, you have any last questions for Cami and Gustavo?
Yeah, this is one that comes up all the time, but I think the lawyers will appreciate the idea that of even a process server. you know, and that has to happen in a certain way, and that there's a profession that helps with that. But I can think of one pop culture reference that always helps. I'm always curious to see if other people carry this one around with them or if I'm the only one. I can think of a very specific pop culture process server.
Pop culture process server. I can't think of one off the top of my head. I know I'm going to know it as soon as you say it.
Seth Rogen's character in Pineapple Express is a process server.
Yeah,
it's like a one gag bit, but it's just the montage in the beginning of him wearing silly outfits and like handing people envelopes.
Right. Yeah, and that's interesting. And people don't understand that goes on. I had to do
and
it.
Smoking pot in his car.
Yeah. I had to do it for years working for a law firm and working for private investigators. It's
I knew as a kid not to answer the door for them because they were always trying to countersue my dad.
Yeah, you get that. You learn those things. But again, we come from different backgrounds. Most of us here are educated, and several of us have lawyers in the family and parents who are lawyers. And so you learn some of these things that other people never had the opportunity to learn. Now I've got $5,000 owed to me, and I need to get it paid back. But how do I do that? So this is a really great tool. I think I like what you're doing. It reminds me of Erin Levine's Hello Divorce in the way that you're doing it. The setup. Have you guys had a chance to meet Erin?
Yeah. She was one of the first people to reach out to us, and I mean, I love how welcoming she was into the community and like the resources she told us to look into. What a wonderful person to have leading this role.
Yeah, she's very supportive of female founders as well. So I'm glad that you got to know her. But the setup reminded me very, very much of what she offers with the guided divorce. So I'm glad that you guys see the parallels there. Cami and Gustavo, tell everybody where they can find you and connect with you and ask you questions and get you on the speaking circuit and all of that. Where can they connect?
So Courtam.com, there's a phone number. You can text it. That's what we tell a lot of our clients. You can call it, and there's an email there. You can email us. I'm on Twitter. He's mysterious.
He's off the grid.
Off social media. I'm on Twitter now because I realized the whole legal tech community is on Twitter.
On Twitter.
I don't know how everyone has so much time for Twitter is what's a little concerning to me. But I do check Twitter, LinkedIn. I prefer Twitter and LinkedIn and text us.
I'm on LinkedIn and Twitter too.
All right. Oh, wow.
I'll connect you to him.
That's great. And the website where she wants you to go is Courtam. That's COURTAM.com. It's a very clean website and very very well done for early stage. I like that. So if you need to get in touch with them, it's Courtam.com. And yes, we are all in the legal tech space on Twitter. I find where we have the time, multiple monitors frees up a lot of time. So,
and bathroom breaks. Nobody wants to talk about that, but
nobody wants to talk about that, but that's where a lot of time things get accomplished. So, and Adam, thanks for jumping in late.
Absolutely.
And please tell everybody where they can find you as well and Juris.
You can find me at the Kerp on Twitter. That's TheKerp. That's really the best place. Everything else links out from there. Just come say hi.
And they can find your company in legal tech space at
getjuris.com. GETJURIS.com.
Perfect. So check them out as well. This has been your Access to Justice episode of the month. This is a commitment that I've had. Anywhere I can get the legal tech and access to justice, I made a commitment at the end of last year to try and do one Access to Justice a month. And if it happens to be a legal tech startup, even better, which is the case with Cami Lopez and Gustavo Lozano. Thank you both for being here. Stay tuned after we stop recording. Thank you, Chris Conjero, Mark Palmer, Diego Alcala, Who else was here tonight? It looks like that was it. Johan Drolshagen. I'm going to screw that up forever, Johanna. Forgive me. And we will see you all next week for episode 78. Actually, next week we have 2 episodes, March 4th and March 5th. We have a special episode with Richard Tromans from Artificial Lawyer. We're going to be talking about Legal Innovators California. That's going to be on June 18th of this year in San Francisco. So we will have a special episode, the second time Richard has been with us, and then next Thursday night at the regular time. So Wednesday and Thursday of next week at our normal time. So keep an eye out for that. Thank you, Cami. Thank you, Gustavo. Thank you, Adam. We'll talk to you soon.
Bye. Thank you.
Thank you.
Have a good night.